Hi guys, welcome back to my channel. Today we're diving into the Susan Lorincz trial, and there have been some new developments in this case, so it's going to get interesting. This article came out 2 weeks ago saying Ajike's family filed a wrongful death suit against Susan for $50,000 that would go directly to her boys. But we know from the trial Susan's family is relatively poor, so I don't know where that money is going to come from. Susan has also filed suit claiming defamation against Ajike's family. She put out this letter defending herself, and she's actually making some of the same points I made in my previous video. To quote Joe Tamburino, a criminal defense attorney and prosecutor on Court TV,
it's going to get dismissed.
I don't really think either of those lawsuits is the appropriate remedy here, and I'm going to present a totally different theory. So let's get into the trial and the evidence in Chapter 2. Susan's next-door neighbor's testimony was very important in this case, and looking back at the body cam footage, she lived right here. From her testimony.
After you heard the door slam, what was the next thing you heard that drew your attention?
My wall in between our two apartments started shaking and pounding on the wall. And it really scared me.
How long after you heard the door slam did you hear that pounding?
Very shortly, within a few minutes.
How would you describe the pounding?
It was very loud, and it scared me because the wall was shaking. And
Miss Owens told you that she said to Susan Lorincz on that night, the next time you walk up on my kids, you're going to have to take it up with me. Right? Correct.
In The Perfect Neighbor, we didn't hear much defense of Susan, so I looked up who the director is. Her name is Geeta Ganbahir, and 3 weeks ago, Haley Sowen wrote on the tab that she has a personal connection to Ajike Owens. Ajike was the best friend of Geeta's sister-in-law, so this documentary is highly biased. That's why this case needs a more thorough and less biased unpacking. Geeta attended Harvard, and her sister's a Superior Court judge for the 3rd Judicial Circuit serving Anchorage, She's directed Alaska. Other documentaries you may have seen, such as Maxine's Baby, The Tyler Perry Story, Katrina Come Hell and High Water, Lowndes County and the Road to Black Power, and Black Table. Technically, what I'm looking at here is the sentencing hearing, but for simplicity, I'll refer to it as part of the trial process. This 3.5-hour long trial gives us key details about Susan's character that we didn't learn in The Perfect Neighbor, and gives us a less biased portrayal of Susan. We hear from 4 character witnesses over the span of only 20 minutes who all say that Susan is a wonderful person, very active in church, very kind and caring, and that they would never expect her to do something like this. We then hear an 1.5-hour long, somewhat confounding testimony from the prosecution's trial psychiatrist, Dr. Yanis Castillo. She goes into great detail about Susan's multi-generational family trauma and her medical history. We also learn that Susan is a disabled older adult. She's had 25 knee surgeries on her right knee, a neck fusion, carpal tunnel in both hands with diminished gripping capabilities, and she has an aneurysm on her left kidney artery. These conditions definitely impacted her thinking when this situation occurred and provide important context that I'm surprised wasn't included in the documentary. To simplify her testimony, yes, Susan has PTSD, but no, it did not affect her at the time of this occurrence, and therefore Susan made that decision consciously and coherently. There's a lot that you could unpack from her long testimony, but I'm going to focus on one of the last questions she was asked where they took a long pause. That's why I'm showing you the full minute here. He asks her, you would agree, based on what you reviewed in this case, that she had no problem engaging people in the neighborhood about issues. And here's her response.
People in the neighborhood about issues.
She engaged people. She indicated that she was seeking support, that she didn't get support. She was trying to talk to the police. So there were like things that she did to solve the situation, according to what she told me.
Yes.
Yes.
Thank you. Your Honor, if I may just have one moment.
Yes, sir.
is my reaction. I'm not a body language analysis expert, but I think we can see here that she knew the answer to that question was not going to be good for their case, but she had to answer it truthfully because she's on the stand under oath, and they needed that long pause to make sure that they asked the next question in a carefully worded way, following up that answer. Centers around property rights, and what people keep pointing out in the public discourse is that this involved a vacant lot that was adjacent to Susan's property, but that was not her property.
Let's be real clear here. None of that property even belonged to Susan Lorincz.
Somebody even made a comment about this on my last video, which we're gonna come back to later. But first, let's look at that vacant lot, which I got a shot of from the body cam footage. In it, you can see the other neighbor's house, who we're gonna call neighbor 2. You can see the front entrance of his house and no windows face the vacant lot the way that Susan's does.
Have you ever personally told any of those children they weren't allowed to do that?
I have not.
Okay, and why wouldn't you be able to do that?
Sorry, the audio got cut off there. He said it's not my property. They're using this as a red herring and a straw man argument. A red herring is when someone introduces an irrelevant point to try to distract from your argument, and a straw man is when someone misrepresents your argument to twist what you said into something easier for them to attack. Using this as a red herring to demonstrate an irrelevant point that you can't tell kids not to play on a vacant lot next door. But the argument isn't over trespassing on the vacant lot, it's over trespassing on Susan's property, and this is what the police said about trespassing.
Somebody trespassing right here, you called us and you saw them on the property, they can trespass. The next time they came out, they go to jail.
There have been some shootings in that neighborhood before, right?
Yes.
He was super fast to object to that.
Shootings in that neighborhood before, right? Yes.
That means this answer is not supposed to be considered as evidence, and that means the jury is not supposed to consider it when making their decision. But it wades us into some murky waters outside of the trial. Luckily, I'm from the South because we're going to go right through it. This brings us to some legal definitions, and just a reminder, this is not the ultimate point here. This is just necessary to go through to get to the point. Specifically, the definition of the word neglect, which doesn't include allowing a child to play outside unsupervised unless allowing such activities constitutes willful and wanton conduct that endangers the health or safety of the child. It says a caregiver's failure to make a reasonable effort to protect a child from abuse, neglect, or exploitation by another person. Wanton conduct is defined as behaving with indifference to the consequences of your actions, acting without concern for potential harm, disregard for the rights and safety of others, and a conscious indifference to the risk of harm. So was it wanton conduct of Ajike to let her kids continue playing outside after the police already told her,
You want somebody trespassing right here, you called us and you saw them on the property, they can trespass. The next time they came out, they go to jail.
and they'd already given her a citation for battery the first time they came out, along with what we know now from the trial footage that there was a shooting in this neighborhood before. I'm gonna analyze this language.
She might not like it because I'm a black female. So.
The key word there is because. Ajike thinks this is happening because Susan is racist. She doesn't see it as she is doing anything wrong, and then the police explain to her. Then Ajike kind of chuckles and says,
The more she says it, of course the children are going to go because they know.
The subtitles were wrong there. She says, the more she says it, of course, the children are gonna go because they know.
The children are going to go because they know.
In this clip, we see Ajike believed she was doing nothing wrong and being corrected by the officers the first time they came there about the trespassing. She challenges it the first time she hears it. Then after they say it a second time, she says, okay. But I think this became confusing when police came out the following times and didn't say the same thing, because it reinforced her belief that she was doing nothing wrong, which allowed for the escalation.
Okay. Landlord put a sign there for a reason. I was voted
We're looking back at the scene of the crime, and we can see that there were many people there when police arrived.
Hey, med bag. Get my med bag. Start giving first aid.
He says, if y'all were here when it happened. And look at who was here when it happened. Ajike's friend, who we saw lied to police on body cam for Ajike in my previous video. As the officer says, just stand right here so I know who was out here when it happened. She walks towards him still for a second, and then she veers off to go away. The woman behind her continues walking toward the officer and looks at her like, where are you going? And I realize that the footage in The Perfect Neighbor is edited and some of it goes out of order, but it at least appears from this next scene that the crime scene tape didn't go up until after paramedics left. Every report I've seen says that Ajike was unarmed, but can we really know that Ajike was unarmed if the crime scene was contaminated?
But did you see her with a gun or another weapon or anything like that?
I don't know what she had on the outside.
What she said there brings us to stand your ground laws, which define when it's justifiable to use deadly force. Vinnie Politan had Mark O'Mara, the defense attorney from the George Zimmerman case, on his show recently to analyze this. The argument that he's going to make centers around these two facts.
The door was never opened, which, by the way, had she gotten inside, that was a burglary, a forcible felony that may have justified the shooting at that point.
So in other words, Ajike had to commit the forcible felony of breaking the door down in order for stand your ground to apply. Now let's hear his analysis.
She literally said I was not using the one right that I had under the statute, which is to use deadly force against somebody because of the imminent nature of the force being used against you. She said I was, in effect, wanting to scare her off.
Here's his argument laid out in a flowchart.
Only use deadly force to repel an imminent use of deadly force against you. You cannot use a gun to scare. You cannot use a gun to say, get away from me.
But this argument skips over an important level of nuance that is often considered in these cases. That intent doesn't equal necessity. Susan saying, I didn't mean to kill her, does not negate a stand your ground defense, because defenders can hope to not kill someone while still reasonably believing that only deadly force would prevent immediate serious harm. Here's his argument flowchart again, and here it is with that layer of nuance put in, and that's whether there's a reasonable imminent threat. I think you could argue the threat was imminent based on neighbor one's testimony and Susan's health conditions. Then I remembered the other fact his argument centers around.
Door. They never got inside, which, by the way, had she gotten inside, that was a burglary, a forcible felony that may have justified the shooting at that point.
I looked up the statute, and it actually reads that deadly force is justified if someone reasonably believes it's necessary to prevent the imminent commission of a forcible felony. So it would at least appear that this
only use deadly force to repel an imminent use of deadly force against you
is actually incorrect, and the correct argument looks more like this. Based on the statute, it's not just whether Susan intended to kill or scare. You also have to ask if an imminent forcible felony was about to occur. And it appears that wasn't being asked in this case. Susan got 25 years for manslaughter, and that seems harsh when we compare it to two other recent cases, the killing of Irina Zarutska and J.T. Schroeder. J.T. Schroeder's killer had stabbed a woman 4 times in 2021 during a robbery. He served just 2 years in prison and was still on probation for that when he murdered 18-year-old J.T. Schroeder in a Walmart parking lot. Manslaughter means that Susan didn't intend to kill Ajike, but this man who stabbed a woman 4 times, I think you could say intended to kill her, and he only got 2 years. You need 4 things to prove someone committed manslaughter. 1, that the defendant caused the death. 2, without malice. 3, by negligence or reckless behavior. And 4, their actions must be a direct and proximate cause of the victim's death. I think they proved number 1, 2, and 4, but by negligence or reckless behavior gets murky when there may be an argument for someone else having negligent or reckless behavior in this case. Most states have stand your ground laws, yet Rockefeller Institute of Government reports they fail to stem crime or improve safety. I'm not really blaming the police officers here too much because it looks like the language in the law is vague and they don't go to law school and learn to interpret it. But they're holding Susan based on legalese, based on her statement that she didn't mean to kill Ajike. But they don't have Ajike here to hold on legalese, and they're also not being questioned on the legalese of negligence in their role. The average American lives in a state with stand your ground laws, so let me know if you've ever been in a situation like this. Now people have donated $500,000 to support Ajike's kids on GoFundMe, which is halfway to the $1 million goal. Let's note who gains and loses here though. Not only did Ajike's family lose Ajike, a mom, a daughter, a sister, Susan's family and friends also lost her, and the police officers lose because it's not like they wanted this to escalate to the point that it did and be on the stand for it. American taxpayers lose because these laws aren't actually stemming crime, they're actually allowing them to escalate further, and then we have to come in and help out with charitable donations. So who wins in this situation? The press is having a field day with it and they profit from the ads and views. Well, the trial psychiatrist got $16,000 from working on this case. Geeta Ganbahir, the director of The Perfect Neighbor, apparently had a $5 million deal with Netflix. Thank you so much for watching. I really hope you enjoyed this video. It's one of my first longer YouTube videos, so I learned a lot. I might re-upload it in the future. Let me know what you think in the comments, and I hope you'll like and subscribe so you can see the next one. Thank you.